They're not illegal aliens, these states. Why are they suing? They don't have to battle with citizenship, they're states. So illegals can file a claim if they're unhappy with this interpretation. They dropped an anchor baby here, and then that guy probably went back and fought in the Taliban. That's a long plan. Sheesh. Supreme Court, you might not like Trump's citizenship ban on birthright citizenship, but it's bigger than that. It's about this nationwide injunction, which is undermining the entire system. President Trump and the Trump administration go into the Supreme Court. This one's over birthright citizenship, a very important issue. The question being, do illegal aliens who break the law and come into this country illegally, who then have children and plop them here geographically in the United States, do those babies have citizenship under the 14th Amendment? Now, for a long time, American law has just presumed, yeah, I guess it's so. And that, in my opinion, has never been accurate. We always have had a question about this phrase, subject to the jurisdiction thereof. If you're subject to the jurisdiction of the country, that means you're abiding by the laws. You're a legal person here with legal residency, legal visa status, or some other basis to be here lawfully. But if you're illegal, you're not subject to the jurisdiction. You're violating the jurisdiction, and that child does not get the benefits of your unlawful behavior. We'll see if that argument makes its way into this. But Trump is filing this to the Supreme Court of the United States. And we're waiting on this because we have a question about injunctions. And we've seen this all over the place. Judges in DC, this case is currently emerging out of Massachusetts, but it's been DC, it's been San Francisco, it's been all sorts of other locations. And the question is, can one local judicial district issue a rule that blankets the entire country? How can one district court judge have more power than the president of the United States and override the president's lawful order empowered by the American people? Seems problematic. So this is coming from Sarah M. Harris, acting Solicitor General, taking this up to the Supreme Court, knocking on their door. This is an application for a stay of the injunction. So Trump issued an executive order, said, guess what? If you're an illegal alien here and you have a baby, your baby is not an automatic citizen. That dumb rule that has been applied by default is no longer in effect because we're interpreting the 14th Amendment appropriately. A district court judge in Massachusetts said, you can't issue that order. Who do you think you are, the president of the country? Now they're asking for a stay on the injunction that is stopping this from going into effect, meaning every single baby that pops out is another citizen. So we've got the parties, we know who they are, of course, the Trump administration. We've got a bunch of other states who are suing in this one, right? Bunch of blue, whiny baby states. New Jersey and Massachusetts and California, Colorado, DC, Delaware, Hawaii, sex-free Corona, Maine, Maryland, Minnesota, Nevada, Rhode Island, New Mexico, New York, Vermont, Wisconsin, and San Francisco County is also there. Now, this has been working its way through a bunch of different proceedings, okay? So a bunch of stuff and kind of companion cases. They're referencing a bunch of other things that are related because they're filing lawsuits in multiple jurisdictions. And most of those jurisdictions have said, well, the kind of the default presumptive rule is that those babies count. So here's what they say now. As this works its way to the Supreme Court, knocking on their door, we want them to accept this. Here's what we've got. They say, all right, Supreme Court, this is President Trump and the Trump administration speaking, saying, hello, court. We are here now respectfully applying for a stay of the nationwide preliminary injunction that was issued by Massachusetts. We're appealing this up to the First Circuit, but we need this to be stopped now. The government is also filing similar applications from other locations across the country. And we're seeing various circuits come up with different opinions, and now they're time to bubble up to the Supreme Court. They say from the following paragraph onward, all three applications are identical. Okay, we're going to be submitting one in Washington, one in Maryland, and elsewhere, but they're all basically the same. They say, all right, court, these cases, which involve challenges to President Trump's executive order on birthright citizenship, raise important constitutional questions with major ramifications for securing the border. But at this stage, the government comes to this court with just a modest request. While the parties litigate weighty merits questions, while we work our way through this in the lower courts, the court here, Amy Coney Barrett, should restrict the scope of multiple preliminary injunctions that purport to cover every single person in the country. So do something about that, okay? We're going to work our way up on the merits on the other things. We know how much you hate it when we jump over the Court of Appeals, but we ask that you limit those injunctions to parties that are actually within the court's power. One judge in Massachusetts can't issue a blanket rule for the whole stinking country, Supreme Court, saying 3 district courts in Maryland, Massachusetts, and Washington have issued overlapping nationwide injunctions at the behest of 22 states, 2 organizations, and 7 individuals, all the blue people. Now, those universal injunctions prohibit a day one executive order from being enforced anywhere in the country as to hundreds of thousands of unspecified individuals who are not even before the court nor even identified before the court. And these overlapping injunctions prohibit federal agencies from even developing guidance about how they would implement the order that actually is lawful. Yet 3 courts courts of appeals refused to limit that sweeping interim relief to the parties actually before the courts, meaning other people who are not even named in the lawsuit are getting a benefit of this lawsuit. They're not a part of it. Your Honors, at the Supreme Court, and what we're seeing here is they're including Gorsuch in a concurring opinion. They say, Your Honor, listen, Supreme Court, this is hardly the first time that individual district judges like this guy have entered injunctions to govern the whole nation from their courtrooms. Gorsuch mentioned that. Such universal injunctions, the type of which we've been seeing here, though a relatively new phenomenon in the era of Trump, have become ubiquitous, posing a question of great significance that has been in need of the court's attention for quite some time. Now, the reasons are familiar. Universal injunctions are legally and historically dubious. That was a 2018 case at the Supreme Court. And someone else said that they are patently unworkable. That was Judge Gorsuch. Judge Thomas also joined in on that in 2018 and 2020 on a concurring opinion. They say this is ridiculous. Universal injunctions transgress constitutional limits on the court's powers, which extend only to rendering a judgment or decree upon the rights of the litigants. You got to be a party to the lawsuit. That's why in a class action, they bundle you together. There's a special process for certifying the class. And if you want to change the law for everybody, you can run for office or you can petition your legislatures to make that change. You don't get to sue and have a judge do that. That's the court acting as a legislative body, not as a judiciary. Gorsuch was joined by Thomas and Barrett. Oh, what's up, Amy? They're calling you out. You agreed with them in this prior case that this was a problem in United States versus Texas 2023. Amy, we see you. I believe, yeah. Amy Coney Barrett, right? Yeah. Concurring in judgments. Universal injunctions are also incompatible with foundational limits on equitable jurisdiction. So it's not even valid in the courts of equity. Alito joined in that one with Gorsuch and Thomas and Kavanaugh. Okay, so now you add in Barrett plus Kavanaugh plus Gorsuch plus Thomas plus Alito. We're getting to good numbers. And Amy, you should accept this case and do something about it. Universal injunctions, like all of these judges have been doing, blue judges, compromise the executive branch's ability to do its job, carry out its functions, as administrations of both parties have already explained. Now, universal injunctions, Supreme Court, couldn't be more true, have reached epidemic proportions since the start of this current administration. Courts have graduated from universal preliminary injunctions now to universal temporary restraining orders, cutting them off before it's even getting to a preliminary injunction. They've gone from universal equitable relief to universal monetary remedies, and they've gone from governing the whole nation to governing the whole world. We can't even have any say in foreign policy now. District courts have also issued more universal injunctions and TROs during February 2025 alone than through the 3 first years of the Biden administration in total. Insane number. They're going nuts. So the sharp rise in universal injunctions stops the executive branch from performing its constitutional functions before any courts even fully examine the merits of those cases and threatens to swamp this court's emergency docket. And so Supreme Court, even measured against other universal injunctions, those at issue here stand out. The universal injunctions here go to all 50 states. They go to millions of aliens all across the country who are dropping babies like it's New Year's or 9 months after New Year's, like it's September, even though tailored interim relief for the plaintiffs to these suites would fully redress their alleged harms. The courts granted these universal injunctions to the states who plainly even lack standing to raise citizenship clause claims. They're not illegal aliens, these states. Why are they suing? They don't have to battle with citizenship, they're states. So illegals can file a claim if they're unhappy with this interpretation, defying the bedrock principle that states, like other litigants, may assert only their own rights, not the rights of third parties. Why are these blue states representing illegal aliens against this country? The courts granted universal injunctions to bar federal agencies from even developing or issuing guidance about Trump's new order. It contravenes the foundational rule that courts cannot restrain the executive branch's internal working. Trump can't even write a memo about this because the judge is now in control, by preventing agencies from formulating or issuing policies in the first place. And individual district courts layered their universal injunctions on top of each other, creating a jurisdictionally messy scenario where the government must run the table over months of litigation in multiple courts. They got to win everywhere, right? In this case, they got to win in Maryland. Then they got to go win in Maine or whatever the other M state was. Then they got to go win in the third state, right? So on and so forth. They got to just win, 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 because one injunction being won, there's still another one that's nationwide and another one all over the same issues. As Judge Niemeyer put it, these overlapping nationwide injunctions exemplify the unseemliness of such a broad extension of judicial power. And these judicial injunctions also exacerbate the existing circuit split over the permissibility of universal injunctions as they're being dropped on us now. Now, this court should declare, Supreme Court, you come out and say, enough is enough, before district courts' burgeoning reliance on universal injunctions becomes becomes further entrenched. The court should stay the district court's preliminary injunctions, except as to the individual plaintiffs who are party to this lawsuit and the identified members of the organizational plaintiffs, the groups that are suing. And if the court concludes that states are proper litigants, even though they're not illegal aliens, as to individuals who were born or reside in those states, then they can be on here. Now, at minimum, the court should stay the injunctions to the extent that they prohibit agencies from developing and issuing public guidance regarding the implementation of this order. Let us do our job. Supreme Court, only this court's intervention can prevent universal injunctions from becoming universally acceptable. Nice. They continue. Knocking on the door of the Supreme Court. They're right. All right, listen, you guys know what happened. On January 20th, Supreme Court, Trump issued an executive order. That order is part of the administration's efforts to stop illegal immigration and to reform the broken system. Section 1 of the order recognizes that the Constitution and the Immigration and Nationality Act confer citizenship upon all persons born in the United States, and here it is, subject to the jurisdiction thereof. Specifically, the 14th Amendment of the Constitution provides that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. Now, that provision is known as the Citizenship Clause. It repudiated Dred Scott, which misinterpreted the Constitution to say that people of African descent were not citizens based solely on their race. That's what it was for. Congress reaffirmed that in 8 U.S. Code 1401, where they wrote and codified this: a person born in the United States and subject to the jurisdiction thereof is a citizen of the U.S. Now, Section 1 of Trump's order identifies two circumstances in which a person born in the United States is not subject to its jurisdiction: when that person's mother was unlawfully present in the United States and the father was not a United States citizen or lawful permanent resident at the time of the person's birth. Okay, mom was not here legally, and she's not a citizen, obviously. If she was a citizen, she would be here legally. And dad is not a lawful permanent resident or citizen, not a United States citizen or lawful permanent resident at the time of the birth. So no lawful reason to be here, unlawfully present, no jurisdiction. You're in violation of the law because mom is not here lawfully and dad doesn't have any connection. Now, when that person's mother's presence in the United States at the time of said person's birth was lawful but temporary, such as but not limited to visiting the United States under the auspices of a visa waiver program, if they're visiting on a student, work, or tourist visa, and the father was not a citizen or lawful permanent resident at the time of said person's birth. Again, those people are here temporarily, not permanently, and they're temporarily subject to the jurisdiction of the country. Then they're out. So Section 2 of the order from Trump directs the executive branch not to issue documents recognizing citizenship to the persons of Section 1, and 2, not to accept documents issued by others. Now, Section 2 specifies that only applies to people born in the United States after 30 dates of this order. So there's a little grace period there. Section 2 also makes clear that the order does not affect the entitlement of other children who are born to lawful permanent residents. They can go, if you're a lawful permanent resident, you can have a baby. That baby is automatically a citizen, according to Trump's order. Now, Section 3 of the order says, create some regulations about this. It directs the heads of the agencies to do the same. Issue public guidance within 30 days. They said they can't even do that. Now, the order from Trump reflects that the Citizenship Clause does not extend citizenship universally to everyone who just happens to be born in the country. The clause expressly excludes from birthright citizenship persons who were born in the United States but are not subject to the jurisdiction thereof. That's in the Constitution. The original public meaning of the term jurisdiction, it refers to political jurisdiction, which turns on whether a person owes allegiance to and is entitled to protection from the United States, right? In other words, you have agreed to subject yourself to the sovereign. I owe allegiance to the sovereign. We have a contract, and you're going to provide protection under the laws of the country. It doesn't mean that there's a law that happens to be on the books and that you break the law, and because you get penalized for entering the country illegally, that you're under the jurisdiction. Like, yeah, we have jurisdiction to prosecute you with crimes for breaking the law. That means you're automatically excluded from this. That's not what we're talking about. But if you come here and you make a contract with us and we say, okay, you can live here permanently and you're going to be like becoming one of us, great. If you have a baby here because you're working and all that stuff, great. You've entered an agreement. But otherwise, you don't get to break the law and get a benefit of that. You steal a candy bar and then sue the corporation and then take the store over? What? A person born in the United States is subject to its political jurisdiction only if, under background legal principles, as understood at the time of the ratification, he owes primary allegiance to the United States. Okay, he's not owing allegiance to another alien power. In fact, Senator Trumbull, back in 1866, said the following, said, what do we mean by subject to the jurisdiction of the United States? What do we mean? Not owing allegiance to anybody else. That is what it means. Not owing allegiance allegiance to anybody else. Doesn't mean that you get prosecuted under the laws of the country. So you're in the jurisdiction, as we use the term colloquially here. Now, applying that test, this court has identified multiple categories of people born in the United States who nonetheless lack a constitutional right to U.S. citizenship. We've already established a pattern here. Children who come from foreign diplomats, children of alien enemies, and children born on foreign public ships in U.S. waters fall in that category because they owe primary allegiance to foreign nations. The diplomat's kids are connected to the diplomat and that diplomat's country. Alien enemies come here, have babies. Those are babies connected to the parents who are enemies of the state. And children born on foreign public ships in U.S. waters, same thing. Unless there's a category, right, where that, it's a citizen type of person. Like, in other words, somebody drives their boat over here and has a baby. Foreign public ships in U.S. waters, they just like bring a bunch of people on a boat. Oh, you're in U.S. national waters. Everybody's just popping babies out on this submarine. Oh, those are all citizens. No. The court has held that the children of tribal Indians lack a constitutional right to citizenship because they owe immediate allegiance to their several tribes. That's the Elk case cited here. Now, in addition, there is a substantial body of historical evidence that shows that the children of temporarily present aliens or illegal aliens similarly are not subject to the political jurisdiction of the United States. This person, called Emmerich de Vettel, the founding era's leading expert on the law of nations, wrote that citizenship by virtue of birth in a country extends to children of citizens or of perpetual inhabitants, permanent residents, but not to children of foreigners who lack the right of perpetual residence. And Justice Story, famous judge who's quoted all over the place, recognized a reasonable qualification to birthright citizenship like the following: the children of parents who were in itinerary in the country or abiding there for temporary purposes as for health or occasional business. You got to have it qualified in this manner. Now, members of Congress expressed a similar understanding during debates over the 14th Amendment. In fact, there was an initial blueprint for the 14th Amendment that was called the Civil Rights Act of 1866. During the debate over these things, Senator Lyman Trumbull explained, he wrote a letter to Andrew Johnson. He says, listen, President, birthright citizenship, if we pass this, it would only extend to persons born of parents domiciled in the United States, like living here lawfully. Another senator observed that persons may be born in the United States yet not be citizens. They're trying to figure out how this works. What happens? There was an example of a person who was born here of parents from abroad who were temporarily in this country. And a representative during this debate said, well, under the general law relating to subjects and citizens recognized by all nations, birthright citizenship did not extend to children born on our soil to temporary sojourners. So if there's a temporary component to this, if we haven't granted you permanency in being here, you don't count. Now, post-ratification practice points in the same direction. Back in 1885, the Secretary of State issued an opinion concluding that a child born of foreign subjects temporarily in the United States had no right of citizenship. Back in 1885, they figured it out. A state Supreme Court determined that the jurisdictional element of the citizenship clause excludes those born in this country to foreign parents who are temporarily traveling here. And legal scholars also explain that the words subject to the jurisdiction thereof exclude the children of foreigners transiently within the United States. If you're here just kind of unaccounted for, you're not a citizen. Now, the court in the Supreme Court in Wong Kim Ark, okay, this is like the big monster case on this legal issue, it addressed this. The question presented in this massive Supreme Court case that the Supreme Court decided back a while ago said, in that case, the question was whether a child born in the United States of parents of Chinese descent who at the time of his birth, subjects of the Emperor of China, okay, so two parents Chinese living here, this is like 1886, I believe, long time ago, and or maybe even before that, looking for a citation here, but it's old, back in the 1800s, says, but have a permanent domicile and residence in the United States. So the Wong Kim Ark parents were lawful permanent residents. So they are not illegal aliens. They were subjects of the Emperor of China, but living in the United States legally. Now, after analyzing that question, that was the issue before the court. The issue before the court was not whether these were illegal aliens, Chinese subjects. They were lawful. After analyzing that question, then the court came to this conclusion, saying the 14th Amendment affirms the ancient and fundamental rule of citizenship by birth within the territory, geographic, in the allegiance and under the protection of the country, including all children born here of resident aliens. It's in the case, resident aliens. The court then summed up its holding as follows. It says, a child born in the United States of parents of Chinese descent, who at the time of his birth, the parents are subjects of the Emperor of China, but have a permanent domicile and residence in the United States, becomes at the time of his birth a citizen of the U.S., which is exactly exactly the language that Trump's executive order is mirroring. This is precedential. Now, this court has since recognized that Wong Kim Ark addressed only the children of foreign parents who were permanently domiciled in the United States. In fact, you guys found that same thing in another Supreme Court case called Kwok Jan Fat, and you found that case in Chin Bak Han in 1902 and 1920. Now, the Justice Department also noted this. They said Wong Kim Ark goes no further than addressing children of foreigners who were domiciled in the United States. And that's a legal term, not like I live in a domicile, I have a house. No. It has never been held, the department continued, and it's very doubtful whether it will ever be held, that the mere act of birthing a child on American soil to parents who were accidentally or temporarily or illegally in the United States operates to invest such child with all the rights of American citizenship. It's ridiculous. Now, during the 20th century, however, our corrupt government, the executive branch adopted, okay, so all of that is case law, but the executive branch adopted the incorrect position that the Citizenship Clause extended birthright citizenship to almost everyone born in the United States, even children of illegal aliens or temporarily present aliens. And there's some argument that this is intentional, okay, like they want to flood the country with foreigners, and some of that might just be economic because people aren't having babies anymore. Some of it might be much more nefarious, but that policy of near universal birthright citizenship has created strong incentives for illegal immigration. Got to just show up here and pop a kid out, and that kid is good. It has literally led to birth tourism, okay? Expecting mothers travel to the United States to give birth and secure citizenship for their children. Fly airplanes in here. It has raised national security concerns as well. It extends U.S. citizenship to persons who lack meaningful ties to the country. In fact, there was a person who was born in Louisiana to temporarily present aliens from Saudi Arabia who returned to Saudi Arabia as a toddler and then joined the Taliban and waged war against the United States. Okay, so they dropped an anchor baby here, and then that guy probably went back and fought in the Taliban. That's a long plan. Sheesh. It's like an 18-year plan. Immediately upon taking office, Trump accordingly issued an order to stop this garbage from happening. Now, the first nationwide remedy, this is Trump going to the Supreme Court, issued from Washington at the behest of 4 states and 2 individuals. They sued. 3 individuals sued elsewhere, other people sued, and more. But then 3 days after the issuance of the order, the district court granted the state a universal temporary restraining order that hit everything. At the hearing, the government asked the district court, they said, hey, can you allow us to do the things that we need to do behind the scenes? Because we think this order is going to be lifted at some point, and we want to start writing memos that we can use as soon as this is up. The judge said, no, you can't. You can't even begin thinking about this in the shower. So then 2 weeks later, the district court granted the state's request to enjoin the implementation on a nationwide basis. The court stated a geographically limited injunction would be ineffective and unworkable. So every baby everywhere who's born to an illegal is now a citizen because this judge overrode President Trump, who was elected by America. This judge was not. Said the government appealed, moved that injunction to be stayed. Nobody took any action on it. Then there was another one, right? Same situation happened in Maryland. Maryland sued. Somebody called CASA Inc. The government appealed, moved for a partial stay. A divided 4th Circuit similarly denied relief. Judge Niemeyer dissented, though. He said, you know, we would grant the government's modest motion here. It's not seeking anything big. It seeks only to cabin the injunction's appropriate reach. And Judge Niemeyer in the 4th Circuit said that he has grave concern about national injunctions, highlighted the unseemliness of such a broad extension of judicial power, and described the preliminary injunction here as presumptuous and jurisdictionally messy. Shout out to Judge Niemeyer. Now, this is an interesting thing that's happening. We're starting to see one question that's popping up as we're going through this is why are they taking this particular case up to the Supreme Court and making this about nationwide injunctions? Is it because, and I don't know the answer to this, but it's worth researching, this might be a more attractive case for Amy Coney Barrett to latch onto and John Roberts? In other words, are they more inclined to grant a remedy on a nationwide injunction problem that is emerging from immigration rather than emerging from USAID cuts? They don't want to touch that right now, but this immigration thing, maybe it does kind of rub Amy Coney Barrett the wrong way or John Roberts the wrong way in a way that USAID did not. So the third case, New Jersey, third nationwide injunction came out from them. The district court acknowledged, they said, yeah, a nationwide injunction does raise meaningful concerns about the scope of this, but if we only limit it to our state, it's inadequate because people can go across the border and travel all over the place and everybody will leave our state, they'll go over here and have a baby. So all the illegals will just, oh, you're pregnant? Let's go over to New Jersey. Now, in the same opinion, addressing the state respondent's suit, the district court addressed a separate suit brought by 2 other people. The government appealed. The Court of Appeals denied the stay. That's why we're here. And the court even said at the lower level that it would not read the plain terms of the district court's order because we can't hear the case right now. So Trump's DOJ goes to the Supreme Court. With all of that out of the way, here is their argument. They say, all right, Supreme Court, this Supreme Court has frequently granted complete or partial stays of universal orders that were issued by district courts before. So don't act like we're here trying to twist your arm on this, Amy. You guys did it in McHenry, you did it in Garland, you did it in Labrador, you did it in Wolf, you did it in DHS, you did it in Barr, you did it in Trump, you did it in International. In many cases, you've done this. The usual stay factors are similar here. And even Amy Coney Barrett, in this case, called Doe's 1 through 3, in 2021 did something similar. And so since you've done this about a million times before, why don't you do it here? We're going to win this anyways, because these injunctions are overbroad in 3 ways. They're not allowed to do this. They grant relief to non-parties, illegals who are not even suing or getting relief. They're granting relief to other states who are not even suing. And they're enjoining the operations of the executive branch, which is our prerogative to execute. Now, the court's overbroad injunctions are causing irreparable harm to the government and to America, and narrowing the injunctions to their proper scope, Your Honors, would not cause any hardship to the only plaintiffs who are properly before the court. And this would be in the public interest, right? And this is another example of an overbroad order, right? They're trying to be overly demanding of Trump so that Trump, but there's this tension here, because if the courts order Trump to do too much, then Trump might refute that and reject that. And then that is the impeachment trap, because Trump is rejecting a court order. We're in a crisis. So they're balancing that, right? They want to push him, but they can't push him too far, because then they get into this territory where it's overbroad, where 3 states are now essentially creating injunctions for all 50. Wait a minute. How does that work? Supreme Court needs to do something about this. The imbalance, the inequity is obvious. It's palpable. It's 3 over 50 over 47. Now, the universal injunctions are granting relief to people who are not even here. Even the judge at the higher court said this is a modest request, okay? The injunctions should not have inappropriate reach. We should not have overlapping nationwide injunctions that could have the effect of preempting or interfering with other orders of the courts. The district courts, say the Trump government, should have limited their preliminary injunctions to the parties properly before them. The individual respondents, the organizations, and the states. That's it. This modest relief we're asking you for would correct the district court's massive remedial foul. These remedies that they're instituting exceed the power of the Article 3 courts. They conflict with long-standing limits on this type of relief. They're imposing a severe toll on the federal court system. And they're referencing the AIDS doctors case, which we've talked about a lot here, which and the recent dissent that came out from that with Judge Alito backhanding Judge Amir Ali in the AIDS case, who of course he came from Canada, you know. So start with the constitutional problem, says Trump. Article 3 of the United States Constitution authorizes federal courts to exercise only judicial power, not executive power, and their power only extends to cases and controversies. They don't get to legislate for the whole country. Under that power, courts can adjudicate claims of infringement of individual rights from individual people, not every illegal alien everywhere in America, whether it was an unlawful action of a private person or something else. Now, courts that sustain these claims may grant appropriate relief, like, for example, an injunction, but they cannot grant relief to strangers to the litigation. Article 3 does not empower federal courts to exercise general legal oversight over the legislative or the executive branch. If they reach beyond the litigants, and if they enjoin the president, their actions toward third parties would be not to decide a judicial controversy, but to assume authority over a co-equal branch of government. And that's what's happening here. The courts are taking over. Universal injunctions from these courts also contravene precedent. Standing in cases is not dispensed in gross. You don't just give people a right to come to court and sue, especially the government. So plaintiffs must establish standing for each form of relief they seek. You have the right to be here because the court can hear your case and the court can do something about it to grant you the remedy that you seek. It can all happen, but you got to be there, and remedy needs to go to you. Otherwise, this is called legislation. These are called national laws, and judges are not elected to interpret or to change those. Now, and a plaintiff remedy must be limited to the inadequacy that produced his injury in fact, right? You got to have some actual injury. Now, even if they have standing to seek relief for themselves, they can't seek it for third parties. They can't even answer the question, right? What's it to you? They're not a party to the lawsuit. So universal injunctions also transgress restrictions on their equitable powers of the courts. Federal courts that are sitting in equity, and equity is like to balance things, must apply traditional principles of equity jurisdiction and may award only those remedies that were traditionally accorded by other courts in equity. Congress may authorize new remedies, but courts may not create their own remedies out of their butts. American courts traditionally did not provide relief beyond the parties to the case. You can't bring in a bunch of other people because you want to. They have instead long followed the rule that injunctive relief should be no more burdensome than what is needed for the plaintiffs who are a party to the lawsuit. Now, unsurprisingly, there have been no national injunctions for the first century and a half of the United States. Notice that? You know, there were also also not criminal prosecutions of presidents until whatever century we're, whatever number of decades we're in now, until 2023. Is that when he first got indicted? 22? So they're changing the whole judiciary, okay, to reshape it in their disgusting image. Now, instead, in a 19th century case where a lower court issued a universal injunction of a state statute, okay, the court agreed that the challenged statute violated the Constitution, but nonetheless held in a separate opinion that the universal injunction was unlawful. It needs to be restricted to the plaintiff only, not anybody who's not a party to the lawsuit. And in a similar modern day precedent, this court also agreed that another law prohibiting federal employees from accepting an honoraria violated the First Amendment, but said the injunction that protected this employee was overbroad. It has to only go to the parties before the court. It's inappropriate to provide relief to non-parties when a narrower remedy will protect the parties to the case. Now, universal injunctions also subvert the Article 3 hierarchy of judicial review. Now, ordinarily, the coercive effect of a court's judgment extends only to the case at hand, right? The judge can only control this. But the stare decisis effect of the court's opinion may extend to other cases, depending on the court's position in Article 3 hierarchy, right? So if you're a low-level court and your court of appeals says something in your district, that's going to be binding on you. But if there's other precedent in other courts, they might look to that and say, well, this is how they're resolving that issue. Now, district court's opinion has no binding precedential effect at all because the district court is at the lowest level, so nothing is binding on them or persuasive in other districts, even in the same district or on the same judge in a different case, right? So that's why all these DC judges are ruling differently. Some say you can sue over a contract dispute and get billions of dollars sent your way. Others say you can't do that. This is a contract dispute. File in the court of claims, your lawsuit is dismissed. In the same district, they're not binding on each other. But of a court of appeals does create controlling precedent that would bind those circuits in that district, those districts in that circuit. And of course, this court decision constitutes controlling precedent throughout the entire nation. So if the Supreme Court decides, everybody everywhere is bound. If this court were to hold a challenged statute or policy unconstitutional, the government could not successfully enforce it against anyone, even in light of stare decisis. But when district courts grant universal injunctions, they upend that system. They override everything. They imbue the orders of courts of first instance with the type of nationwide effect usually reserved for precedents of the court of last resort. They're kind of taking power away from you, Supreme Court. Now, these universal injunctions also render meaningless rules about joinder and class actions, okay, as we mentioned before. Take these cases. The individual plaintiffs in Washington, they sought to represent a class of affected pregnant persons in the Washington state. Yet, instead of asking whether the individual plaintiffs actually satisfied a class certification, the district court just granted a universal injunction. Did they even certify them as a class? We don't care. You got your injunction. The court thereby then granted even broader relief than the proposed class could have sought. It's way bigger than the class. It's everybody across the whole country. Now, the universal relief can also sweep up non-parties who may not even wish to receive the benefit of this. 18 states in Washington filed an amicus arguing that the citizenship order is constitutional. In other words, there's a bunch of states who want the Trump order to be in effect. And this judge is usurping their rights too. But the district court's injunctions prevent the orders from taking effect in the other 18 states who've even made their voices heard that they want this to happen. Universal injunctions cause significant harm to the government. They invite forum shopping. You get guys like Norm Eisen who just take them to different jurisdictions like San Francisco. Different challengers need not file different challenges in different courts. If one files one suit in one court, can secure victory nationwide. You go to the best judge you can find, sue there, know that they hate Trump, and boom, your corrupt law firm suddenly has their privileges back. They force the government to seek immediate relief, go from one court to the next, and finally, we got to scramble in front of the Supreme Court. They countermand the principle that the government is not subject to non-mutual issue preclusion. In other words, that the government may relitigate an issue against one party, even if it has lost that issue against another party in another case. Okay, so in other words, if the Trump administration wins and beats these lawsuits in New Jersey, they can't take that order and say, we literally cannot be sued about this in Maryland. They don't have that right because it's a separate claim. Whereas other litigants in other claims, right, could do that. So if you're being sued personally, like, he sues you here, you beat him, he sues you in another jurisdiction on the same issue, you say, I already beat you on this, okay? Stop shopping for forums. Can't do that against the government. And they operate asymmetrically. They grant reliefs to strangers everywhere. Whenever a single plaintiff prevails, and it doesn't preclude continued litigation by others if some plaintiffs lose. So if they lose, like on one suit, they just go and win here, win over there, win over here, get it nationwide. And finally, Supreme Court, universal injunctions harm the courts. By their nature, universal injunctions tend to force judges into making rushed, high high-stakes, low-information decisions. They exert substantial pressure on this court's emergency docket. They force the court to confront difficult issues without the airing of competing views, multiple judges, multiple circuits. They encourage needless confrontations all over the place. Now, the district courts are not addressing these concerns. They're resting on precedent-defying rationales. They're authorizing nationwide injunctions in virtually every case. This should have been granted only to the people who were here. The Casa District lawsuit deemed universal relief appropriate. They just called it a categorical policy. And they said that Congress can establish the rules and the president has to follow them. Same thing in Washington. And all that being said, giving us a summation of what's happening in the other lawsuits, let's talk about the equities. Now, to put it mildly, universal injunctions irreparably harm the executive branch by preventing a branch of government like Trump from carrying out its work. We have those four factors, and now we're asking ourselves on this factor of kind of balancing. Is it better for the public? Is it more harmful to one party or another? What are the benefits? Does the benefit outweigh the harm? The president holds that the mandate of the people to exercise the power. That's the president. The executive branch also exists to carry out his policies. Now, courts do play an important role in adjudicating the lawfulness of those policies in justiciable cases when people can actually sue, but they irreparably injure our democratic system when the judges forbid the government from effectuating these policies against anyone, anywhere in the nation. Roberts even said this: anytime a state is enjoined by a court from effectuating statutes enacted by the representatives, that is a form of irreparable injury. We are being injured right now by the courts. We had a say in the election. The courts are interfering and insurrecting our will. Aggravating that irreparable harm, the district court's universal injunctions also interfere with the executive branch operations. They prohibit agencies from even developing or issuing guidance to explain how this order would be implemented. This court should grant stays to correct this. This is an intrusion into the federal government by the federal courts. And these universal injunctions also impair the president's efforts to address the border crisis. In recent years, the United States has faced an unprecedented flood of illegal immigration. Immigrants, millions of illegal aliens, crossed our borders or permitted to fly directly into the United States like Uber for illegals, thanks to Joe Biden and the Democratic Party. Many of these aliens unlawfully within the U.S. present significant threats to security and public safety. Some have engaged in hostile activities, including espionage, economic espionage, preparations for terror-related activities, and their presence in the U.S. has cost taxpayers billions at multiple levels. The district court's injunctions threaten to perpetuate those problems by holding out a nationwide incentives for illegals. What is it? The prospect of American citizenship. They break the law, their kids and them get a bunch of benefits. And then you have people like Nicole Wallace. You can't separate families. They broke the law to drop a baby here, and then you are screaming you can't deport them for literally breaking the law to do that, to exploit our country. On the other side of the ledger, narrowing the scope of the district court's injunctions so that they only apply to the people who are parties to the lawsuit is reasonable. A party-specific injunction would fully redress any injuries that those people might face, but by contrast, harms to the states are not pertinent, and third parties are not pertinent. The traditional stay factors require a court to consider whether a stay will substantially injure the other parties. Now, state respondents are not proper parties to the proceeding, so the states and everybody in the state shouldn't count. They're not third parties either. Accounting for their interests in weighing the equities would contravene a rule that strangers to litigation are not the proper object of the court's remedies. Now, finally, they write, issuing a stay would serve the public interest. The district courts in these cases emphasize that the public has a strong interest in enforcing the citizenship clause and upholding the rule of law, but universal injunctions are thwarting that. They undermine Article 2 and Article 3 and the citizenship clause that make up the Constitution. Whatever the Supreme Court views of this lawlessness of the citizenship order, universal injunctions are plainly inappropriate means of redressing any harms to respondents. So, Supreme Court, you might not like Trump's citizenship ban on birthright citizenship, but it's bigger than that. It's about this nationwide injunction, which is undermining the entire system. The public interests support granting this modest application. It seeks only to cabin the inappropriate reach from the lower level courts. And moreover, granting stays would simply allow the agencies to resume their work developing and issuing the guidance here. Work that never got off the ground because they immediately issued an order. Granting relief would not mean that affected individuals would need to file thousands of separate suits either. Affected individuals could just come, get certified as a class, and if appropriate, seek a class-wide relief. Washington individual respondents even sought that procedure. But so long as putative class members all have standing, that approach, unlike the issuance of nationwide injunctions, actually complies with the rules because they are actually people who are affected by this. That procedure also avoids the asymmetric stakes of nationwide injunctions. A class judgment binds the whole class, but one plaintiff's loss in seeking a nationwide relief does not stop others from trying again, right? So if they file a class, which is why they don't want to do that, because if they file a class and they lose, they're done. So there are more than 1,000 active and senior district court judges sitting across 94 districts in America. Years of experience have shown that the executive branch cannot properly perform its functions if any judge anywhere can enjoin presidential actions everywhere. The sooner universal injunctions are eliminated root and branch, the better. And so in conclusion, Trump's DOJ, Acting Solicitor General Sarah M. Harris writes, Your Honor, Supreme Court, this court should stay the preliminary injunction, except as to the two individual respondents who are actually going to be impacted by this. And if this court concludes that the state respondents are proper parties, as to individuals who are born and reside in those states only. In Trump, the court should stay the preliminary injunction, except as to the 5 individual respondents and the 11 members of the organizations. And in New Jersey, the court should stay the preliminary injunction in full, or if they conclude that the states are proper, except as to people in those states. Now, at a minimum, this court should stay all 3 preliminary injunctions to the extent that they prohibit executive agencies from developing and issuing guidance so that we can implement this immediately in the event that we can and that takes effect. So, great filing here by Sarah M. Harris. And I think about the consequences of this. Okay, what if they are not nationwide? So, for example, New Jersey, Washington says, no, we in Washington are going to pause Trump's executive order, but a bunch of other states allow that executive order to go into play. So the federal government will honor the state determination that babies born there are not automatic citizens. We'll have this alignment between the feds and the state governments, let's say in the red states. Then as to the blue states, any baby born there is an automatic citizen of the United States and a citizen of that state. So what does that do for the migration patterns of people who are already in the United States? Okay, let's say people are not coming across the border in spades anymore, in droves, but a bunch of people now, at least who are pregnant, are going to want to migrate to those states, right? Leave a red state, go to a blue state so that if you have a baby, it's an automatic citizen. And that would be interesting to see. And I'm for it, actually. So if the Supreme Court grants this and these stays are limited and cabined, you'll see a bunch of people, I would imagine, fly out to Washington or drive out to Washington and get out of the other states, which would be a good start. So that was filed. We're going to keep our eye on this one. Of course, we're going to see a bunch of responses from all of the lawyers involved in all of those cases, but the Supreme Court of the United States now hearing birthright citizenship, and much bigger than that, this might resolve all of these injunctions, okay? If the Supreme Court comes back down and issues a blanket rule that says, all right, they're only limited to the state, or there's some other mechanism where they write an exception, if a lower level court issues a nationwide TRO, you know what? We will hear your case immediately at the Supreme Court. You can bypass everybody because we know it is in effect an injunction against the executive branch, which is an impingement upon the American people. We hope we see some progress on this. Amy Coney Barrett, we love you. Please love us back. Let's make it work. We want to make it work. Amy Coney Barrett and John Roberts. So hopefully we get some good news on this. We're going to cover it. Thanks for subscribing and joining as we do.